Oh no! I just received this notice from the land office. It says my land will be acquired for a government project. What should I do?
Don't panic. I think you will need to attend an inquiry. They can simply take your land without following legal process. I also heard you need to bring important documents. You can also hire your own private valuer if you disagree with the compensation.
That's correct. Before any compensation is awarded, an inquiry will be conducted to verify ownership, examine the required document, hear all interested parties, and determine fair compensation according to the law. So, how would this inquiry actually work?
Let's find out in today's presentation.
Assalamualaikum and good morning. Today I will be presenting for our task. The topic is Enquiry and Award by Land Acquisition.
My name is Norshel Juliana binti Sabtu.
Hi, my name is Nurhana Safia binti Hindi.
My name is Nurul Najwa binti Muhammad Anwar.
My name is Nurul Aiman Sarah binti Muhammad Rashid.
These are the procedure before the land administrator can conduct an inquiry under Section 12. Section 7 equips the state authority with a complete data to decide on acquisition under Section 8. The land administrator prepares a plan showing the entire acquisition area with a clear dividing line if only a portion of land is being taken. And a written list in Form C containing lot numbers, strata numbers, proprietors, and areas. For unbroken land under the subsection 7.2, such as MRT tunnels, the plan must describe the subsurface extent. Also, in March 8, Sedan Berhad versus Kerajaan Negeri Selangor, the Federal Court held that Form C must be finalized before Form D is gazetted and no amendments are permitted afterward. Moving on to Section 9, Section 9 gives both actual and constructive notice. Under subsection 9(1)(a), the land administrator physically marks out the land using bags, giving landowners actual notice. Under subsection 9(1)(b) and 9(2)(a), the administrator notes the acquisition in official records in two places. The first is the registered document of title at the land office. The second is the strata registered under the strata title tax 1985 for subdivided buildings. This provides constructive notice to anyone conducting a title search. Next, Section 9(a). Ensure valuation is based on accurate land use information. The land administrator requests official land use data from the planning authority on three matters: whether the land is within a planning area, whether a development plan applies, and the specific land use designated. The authority must respond within 2 weeks. Under Section 9(a)(5), the information is conclusive evidence for valuation. Moving onwards on Section 10, formally commences proceedings. The land administrator must issue a public notice in Form E and fix an inquiry date under subsection 10(1). In subsection 10(2), establish a safeguard as the inquiry cannot be held earlier than 21 days from publication. This waiting period gives landowner time to prepare their claims and secure representation. Subsection 10(3) requires the Form E schedule to be appended to every Form E notice. The last procedure is Section 11. Section 11 ensures personalized notice to all interested parties. The land administrator must serve Form E on 4 categories under subsection 11(1). These are the occupier, registered proprietor if an occupier, any person with registered interest such as mortgagee, and any person the land administrator believed to be interested, such as tenants or beneficiaries. The land administrator is excused only if the register is physically damaged. Under subsection 11(2), the land administrator may issue Form F to require a legal statement of valuations, interested person, and rents for the preceding 3 years.
We want to document that needed by land administrator before proceeding the inquiry. The first document is Form A, which is the preliminary notice that land is likely to be acquired under Section 4. Once the state authority is satisfied that the land is needed for a public purpose, Form A is published in the Gazette and public notice is issued. It is important to note that Form A will lapse if it is not Gazette within 12 months. For example, case of law, United Allied Empire Sendirian Berhad with pengarah tanah and galian Selangor and Ors, the Court of Appeal ruled that the acquisition was unlawful because the government failed to follow the proper legal procedure, including the publication of Form A. Next is Form C, prepared under Section 7. This form contains the list of land to be acquired together with a plan showing the affected area. If the acquisition involves underground land, the plan must also describe the underground area. After that is Form D, which is the official declaration that the land is required for acquisition under Section 8. Once it is published in the Gazette, it becomes conclusive evidence that the land is needed for the state purpose. The land administrator must complete the acquisition process and make an award of compensation within 2 years. In the Orchard Circle Sinabalat with Pentadbir Tanah Daerah Wilayah and Ors case, the Federal Court decided that Form D remained valid because the acquisition process had already commenced within the required period. Following Form D, the land administrator records a note of intended acquisition under Section 9 by marking the land and entering the notice into the land register. Next document is Form E, which is the notice of inquiry under Section 10. It is informed all interested parties about the inquiry date, allowing them to submit their compensation claims. The inquiry cannot be held earlier than 21 days after the notice is published. after the notice is published. Finally, Form S is issued under Section 11 to require the registered proprietor or other interested person to provide written evidence or relevant information regarding the land acquisition.
This presentation outlined the requirement for documentation during the land acquisition inquiry process. As detailed in our group report, the first key area is providing documents and evidence. The main goal here is to establish a clear foundation for ownership and land value before compensation is decided. Under Section 12, the land administrator may seek a professional valuation to assess factors such as location, land size, and market conditions. The second area focuses on ownership confirmation and legal records. Under Section 13, the LA land administrator has the authority to request necessary legal documentations such as land grants and purchase contracts. This identify all stakeholders, including tenant, and ensure all evidence such as witness testimonies is maintained in an official record under Section 14 for full transparency. Next, examine the statutory forms. Under Section 13(2), two documents are critical, which is Form E, serve as the official notice informing parties of the date, time, and locations of the inquiry. Form F allows claimants to provide specific details regarding their interest in the land, the amount of compensation they are seeking, and evidence for any improvements such as crops and building. Next, we must consider legal importance and compliance. It is vital to provide accurate information, as failing to do so can lead to penalties under the Penal Code. Furthermore, established case law confirm that the issuance of both Form E and Form F is mandatory for proper legal procedure. Next, I will explain the procedure and appointments involved in land acquisitions. As shown in our slide presentation, the process begins with the appointment of a private valuer. After the landowner receives Form E, the valuer acts on behalf of the landowner and conducts a detailed site inspection to collect property and market data, assessing factors like market value and potential losses. Next, the valuer prepares a professional report to support the compensation claim and assist the landowner during the inquiry. Finally, the land administrator assesses the compensation by reviewing the JPPH valuation report, the private valuation report, and all evidence submitted by the parties. After this assessment, the land administrator finalizes the compensation amount and issues Form G, the award of compensations, and Form H, the notice of award. Furthermore, process of appeal and judicial review in land acquisition as illustrated in this explanation. If a landowner is dissatisfied with a compensation decision, they may file an appeal under Section 37 of the Land Acquisition Act 1960. During this process, the High Court will review the decision, taking into account expert opinion from both government and private valuers before reaching a final judgment. A notable example is the case of Sunrise Prince Neighborhood versus Pentadbir Tanah dan Galian Wilayah Persekutuan Kuala Lumpur. In this case, the private valuation was disputed against the government assessment. Ultimately, the court found the private valuation more convincing, which led to an increase in the compensation amount. This case highlights the important role of private valuers in ensuring fair and equitable compensation for landowners.
So moving on, I will continue to explain about the challenges by land administrator during inquiry proceeding. The first challenge is determining the market value under Section 14(1). The compensation must reflect the actual market value of the land at the acquisition date. However, differences in valuation method and limited comparisons often make this process difficult. This principle was confirmed in N. Hong versus Collector of Land Revenue Gombak at 1984. In this case, the court held that compensation must be assessed based on the market value of the land on the date of acquisition, and future development potential cannot be considered. For the second challenges is identifying all interested persons. Besides the registered owner, there may also be tenants, chargeholder, or beneficiaries who are legally entitled to compensation. And the third challenge is obtaining sufficient evidence under Section 30. The land administrator requires complete documents such as land title and valuation reports to ensure that compensation is determined fairly. Moreover, for another challenge is balancing public interest with private property rights. While land acquisition is necessary for development projects, Article 13 of the Federal Constitution requires adequate compensation to be paid. This was emphasized in the case of Sagung Tasih versus Kerajaan Negeri Selangor, that compulsory acquisition must always be accompanied by fair and adequate compensation. This case shows that compensation is not only a legal requirement under the Land Acquisition Act, but also a constitutional right that protects landowners. But the next challenge that involves objection to compensation. Under Section 37, this is defined that owners may refer the award to the High Court, which can extend the acquisition process. This was reinforced in the case of Pentadbir Tanah Daerah Gombak versus Wat Heng, which is the court highlight that compensation award should remain subject to judicial scrutiny to ensure that the valuation follows the legal principle and statutory requirement. This case demonstrates the importance of transparency and accuracy when determining compensation, as any error may result in the legal proceeding and delay in the acquisition process. Lastly, the land administrator must ensure that the inquiry complies with the principle of natural justice by giving every interested party a fair opportunity to present their claims before any decision is made. Next, I will explain the procedures for giving an award by the land administrator under Section 14 of the Land Acquisition Act 1960. After completing the inquiry, the land administrator is responsible for determining the amount of compensation payable to every interested person. The award must be fair, transparent, and based on recognized valuation principle. And for this principle is supported by the case of Enquiry versus Collector of Land Revenue Gombak 1988, and in this case the court held that the compensation must be assessed based on the market value of the land at the date of acquisition, and future development potential should not be taken into account. This ensures that compensation is objective and legally justified. So, for the first step is the preparation of Form G under Section 14(1). The land administrator is legally required to prepare a written award after completing the inquiry. Form G records the amount of compensation for each parcel of land. And for the next step is the land administrator identifies every person who is legally entitled to receive compensation. Separate awards are prepared for registered owners, the land is whole, or any other person with a recognized legal interest. And moving on to the third procedure, the compensation amount is determined using the valuation prepared by JPPH. The valuation considers several factors such as the land's location, accessibility, comparable market sales, and developmental potential. Moving on, after Form G is completed, it is filed at the Land Administrator's Office under Section 14(2), and once filed, the awards become final administrative evidence regarding the land acquired, the person entitled to compensation, and the amount awarded. The next step is the payment of the compensation. If there is no dispute, payment is made directly to the entitled parties. However, if ownership or entitlement is disputed, the compensation will be deposited into the High Court until the dispute is resolved. Although the award is final at the administrative table, dissatisfied parties still have the right to refer the matter to the High Court for a review of the compensation. This provides an important safeguard to ensure fairness.
To conclude our presentation, I would like to summarize the key points regarding land acquisition as shown in our report finding. First, land acquisitions require a careful balance between the public interest and protecting the rights of landowner through a fair and transparent process. Effective cooperation between the land administrator, landowners, and professional valuers is essential to ensure accurate compensation and reduce potential disputes. Furthermore, applying proper property law and evaluation principles shows why professional judgment is vital for achieving equitable outcomes. Finally, understanding the process provides real estate management students with the essential knowledge, ethical awareness, and practical skills needed for future careers in the property industry. Thank you for your time and attention throughout this presentation.